Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. Let me introduce you to our four panelists that we have today. First, we have Mr. Andre Wong, who's the General Counsel and Director of Public Affairs and Religious Liberty for the North Pacific Union Conference of the Seventh-day Adventist Church. We have Ms. Bettina Krause, who is the editor of Liberty Magazine. We have Ms. Jennifer Woods, who's the General Counsel and Director of Public Affairs and Religious Liberty for the Lake Union Conference of the Seventh-day Adventist Church. And we have Mr. Rashawn Baker III, who's the President and CEO of Baker Strategy and a University of Maryland Professor of Public Policy. Ladies and gentlemen, good having you guys here with us. Looking forward to our conversation today. You know, we had a segment where we had a talk about the idea of silence being something that's protected. However, there's also this other protection that deals with when someone is giving a secret confession to their minister. Well, the California Code came out with something that had to deal with evidence that protects confessional privilege only if the confession is rendered by one penitent to one religious minister. But what we're starting to see is that what do you have when you are in a situation where you basically have that same conversation with more than one minister? Should that still be in effect so that you can be protected? And we have the court that actually starts dealing with this in California. You know, Jennifer, can you give us a little bit of color regarding this whole concept and why it's so important? Because it looks like the Catholic Church, who really engages in a lot of this activity, may find themselves in a bit of a bind.
Yeah, so for many, they think of the confessional privilege as something that's based on a one-to-one model that's typical in the Catholic Church, where you're confessing as part of a sacrament, right? And the priest is able to absolve you. And for that reason, many courts have said, okay, we're going to privilege this. And many states have said, we're going to privilege this confessional event that's happening between a member and their priest. But there have been cases out there that have been decided that say, hey, you know, we're not going to limit this to the Catholic model of this one-to-one confessional type discussion. So there have been cases where a pastor has been found to still be able to invoke the confessional privilege, even if they've later discussed what was said with co-workers who are ministers as well, who could also invoke that same privilege. And courts have also found that this privilege can be invoked even if it's not a one-to-one, where let's say that someone comes in and they're giving a confession or they're getting counseling and they have someone else in the room with them. So, you know, states are looking to broaden this privilege beyond just this one-to-one model that is typical in the Catholic Church and Orthodox churches, because many faith traditions don't have that same kind of confessional model in place.
And I think it's important to take a look at why these privileges exist. You know, they exist because the law recognizes that there are certain special relationships that are sacrosanct. You know, we're talking about the pastor-parishioner privilege, but there's the attorney-client, doctor-patient, therapist-patient, the spousal privilege. You know, but here, you know, it recognizes the literally sacred role the clergy plays in society, and that individuals should have the protection of confidence in disclosing bad acts, bad thoughts, and to receive comfort and counsel from their pastor without fear of reprisal. You know, so you know, but it's interesting to note, you know, what is a privileged communication? You know, a disclosure that is made privately and not intended for full disclosure, made in the context of the pastor's role as a spiritual advisor, is the baseline standard, right? But other states have unique applications, like Montana and Wyoming, for example. The privilege only applies to confessions. And I believe in the California case, the privilege only applies to if the pastor is also obliged to confidentiality under the tenets of their denomination. So at least in principle, the privilege is a legal acknowledgement of the sacred role pastors play in the lives of their parishioners.
You know, Mr. Baker, you've been in a jurisdiction that had probably more churches than I could even throw a stone at, and pastors who are constantly doing counseling. If we start getting too formal with this process and really trying to look at a structure that may exist, for example, in the Catholic Church, do we start to tighten this up so much that we're really kind of taking away really that true relationship that a spiritual advisor or leader can have, and hopefully have it in a way that's protected?
No, you're absolutely right, Orland. I know, as you do, I served on a judiciary committee in the General Assembly in Maryland. And so issues like this come up a lot because you think about it, especially in the Baptist church and some of our larger one, you have co-pastors, could be a husband and wife or another minister that actually ministers to the faith. Or you take a church like in Prince George's County, which has some of the largest churches in America, where you have 10,000 members, you may have the pastor, the assistant pastor, and another pastor in that. So I think you're starting to tighten the screws on this when you just take the Catholic model and that confession within the booth, or even in the Jewish faith. So I think that's going to be one of the issues that looks at, the legislature will look at and the courts will look at is, if the courts rule, let's say like what they're talking about in California, I think you'll see a lot of legislatures trying to come to jump in and really try to make sure it goes back to what the traditional understanding is for the various faiths, so you cover everything.
No, but Tina, it looks like there's a question, though, of how formalized this is. You know, as Mr. Baker just mentioned, sometimes you have pastoral teams that are husband and wives that are meeting with other couples, and you could, quote unquote, just be out having, quote unquote, dinner with another couple, and you as a husband and wife happen to be ministers. You know, how formalized do we have to get before that confession actually is something where we feel it can be protected?
You know, and Orland, I think this goes to the point that this area of law is such a patchwork at the moment. I mean, we have 50 different states with 50 separate statutes controlling rules of evidence, and many of them have very different approaches to this. I mean, in some states, a handful of states, this privilege is actually abrogated in instances where someone is confessing child abuse, for instance. And so, you know, you have all these different standards, and really it's such an odd area of law. I mean, look at it historically. It came from Roman Catholic canon law. That's when it developed in medieval times. And its strange character, I think, is reflected in the uncertainty that continues to exist around it now. I think going forward, Orland, as we look at this area of law, I think we need to ask ourselves a bigger question, which is not just what it protects, but what it doesn't protect. And, you know, I think there is a fruitful conversation to be had there regarding areas where it really shouldn't be extended to cover confessions, especially in cases involving vulnerable children.
Wow, so we're looking at a situation, Jennifer, where maybe this whole protection or confession should only apply in certain sets of circumstances, maybe. And it looks as though when the Supremes are looking at this, the conversation seems to be leading to a more broad construction of how we may be able to do or allow this to take place. So I see a little bit of a conflict that's taking place there. You know, what side do you think, basically, from your perspective, that we may want to lean, and what would be the benefits of it?
Well, I think that Bettina, you know, she raised some really interesting points, especially as far as this is not an absolute, right? When we're dealing with issues of child abuse, there are limitations to the protections that a clergy would have, because there are some reporting requirements that kind of trump those things. And I think that, you know, she also mentioned this notion that this is kind of a patchwork because of its history. And, you know, as I was thinking about this, I said, like this came out of the Catholic tradition. We're trying to apply it broadly to other faith traditions. And even, you know, as we look at like the federal rules, it includes ministers, priests, rabbis, or someone who works in a similar function. But I can imagine that there's still some faith traditions that might not have, that this model doesn't apply to.
Right.
And so it's hard to have a privilege like this, no matter how broad it tries to be framed, that doesn't seem in some ways to privilege some kind of religious conversations, but not privilege other kind of conversations, just depending on what the faith tradition is.
You know, Sharon, I'm having a flashback to being in evidence class and remember my professor talking about this, and they kept saying, your privilege goes whenever somebody else shows up. Your privilege goes when somebody else shows up. It looks like that whole mantra that there could be more than one individual, quote unquote, in the room or part of the same conversation, that maybe from a religious standpoint, we're trying to give you a little bit more than you might get in other circles. Am I going too far with that?
No, I think you've hit the major question right on the head, and that is, traditionally we say if anybody else is in the room, it's gone. But in this case, just think about the various faiths that we have throughout our country and trying to deal with something as sensitive as faith. And that is, like I said, you could have co-pastors, you could have an imam, co-imams, you have all these different faiths or non-denominational religious. So I think the struggle with both the court and the legislative body is how do we make sure we're not, suppressing religious freedom, at the same time making sure that we are not giving broad cadence to things that we need to have that information, as was brought up about, whether it's child abuse or domestic violence, and those issues we're struggling with. And so I think that's why this is such an important question now, given everything that's going on in our country. And so this is one of the areas where the old rule kind of goes out the window until we actually get a new rule.
Well, Andre, what I think is interesting is the idea that Bettina brings up, that we are looking at a construct that got created during medieval times. And as a result thereof, we still seem to be using this as kind of like the platform of how we're doing, what we're moving forward here. It stands to reason that maybe it's time to update this whole concept, maybe put it in a mechanism where we all can be comfortable so that everybody can be covered in some way, and it may not necessarily mirror exactly how their religion works. What do you think about that?
Yeah, and so with every privilege, there is there are exceptions, and going back to evidence class, we remember the Dauber and Tarasov doctrines, right? That the privilege can be breached by a therapist if they have a well-founded belief that the patient poses an imminent harm to himself or others. And so that I think that is really the spirit of the mandatory requirement disclosure for child abuse. But when it comes to the multiple people in the room, I go back to my original comments of the law looks at the nature of the relationships between the pastor and parishioner or the attorney-client. The discloser or the parishioner is the holder of the privilege. Mm-hmm. So you look at first the nature of the relationship between the two parties, or if there's another the two pastors or two lawyers in the room, but then you also look at the intent of the discloser. Was the communication made with the intent that it not be disclosed and be made public? And was it made in the context of the special relationship that they have between the two?
I think that's exactly the way we've got to look at it. This is going to be a topic that we're going to be looking at probably for some time now, because we've got so many different religious groups that are seeing things so many different ways. And to utilize one construct that currently exists to kind of make that the law of the land is going to be very, very tricky. So we'll have to see how this really turns out. We make some comments from time to time regarding that probably outside the United States, only 20% of the people get a chance to serve their God the way they see fit. But we do have some religions that actually are outside that find themselves inside. And here we're talking about a particular case that actually is entitled Belya versus Kapral et al. And it has to do with a Father Alexander Belya, who claimed that he was elected as a vicar bishop in the Russian Orthodox Church outside of Russia. And the church and its leadership insists that he was not and that he is not qualified to be a bishop. And in a letter to the church's senior leadership, several of the leaders expressed concern over the credibility of the supposed election with the father Alexander's performance of his priestly duties. This is the question that I have. We want churches to be able to run their organizations the way they see fit. However, when you see individuals that start having what we might even call employment issues in the midst of a church environment, how do you get a chance to juxtapose this in such a way where our churches are not using its power and its exemption as a sword when it should be used more as a shield? Bettina, take us a little bit through this case to understand what's going on.
Well, Orlin, I have to say, when I looked at the facts of this case, it seemed to me that this was clearly an internal church dispute. I couldn't think of any clearer situation where the doctrine of church autonomy should apply. I mean, we've got two sides of the coin. We've got the free exercise clause of the First Amendment, which says that religious groups must be free to choose their own leaders, ministerial exception. Flip side of the coin, we've got the establishment clause. The government can't get into the business of a church. You can't meddle in its internal affairs because that would breach separation of church and state. So, what is happening here, sure, there are issues where the father involved, the plaintiff could make a case that he was being treated unfairly. But in order for a court to actually ascertain that, they're going to have to get their hands deep and messy into church governance and church doctrine. And that, to me, is the big red flag that says you can't go there.
Bettina, I agree. When I was looking at this case and I was reading, the plaintiff's side, I was reading the defendant's side, and the way that it was framed from the plaintiff is, this is just a case of defamation, right? It's just a question of were they truthful? Were they spreading lies about this father? But then, as I continued reading, it's like, well, you can't really answer that question about defamation without getting into the weeds, right? So on its surface, it sounds like it's just a simple defamation case, but as you start really digging into it, it's like, no, the government will have to get involved and entangled into the inner workings of the church. And that is why, there are laws that say, no, there's a ministerial exception. We don't get involved in these things. We let the inner working of the church be handled by the church. So, at first I was like, well, maybe, but I came to the same conclusion that you did on this one.
Well, it looks like the Second Circuit on this, Rashawn, decided that that Father Belya's case should go forward against the church, and that they came to the conclusion that there may be something of merit here. And I guess the question is, how do we find ourselves in a position where if we want to make sure that there are employment laws that exist in this country, however we want churches to be able to do what they think is most important to do, that there has to be, again, that clear word balance. But in the same breath, unless you get into the weeds, how do you know whether balance has been, utilized or not? Rashawn, how do you see this kind of playing out?
Well, I think you're absolutely right, Orlin. On the surface, both you look at the case and you say, okay, well, you're going to have to get in the weeds of the church doctrine in order to understand it, and therefore maybe we should stay out. The problem becomes that both in the court system in the United States, but also in our legislative system, we have gotten into the weeds of religious organizations, how they function, when we think they're violating some of the laws that we have, employment being one, and other issues. I remember in the legislature, we dealt with the Jewish faith and divorce, and the fact that in the settlement of divorces, the husband had a religious doctrine that he could use against the wife. And then they wanted to bring that into the court system and say, well, that person has to give up that, I think it's the got or something for a divorce so they can remarry in the Jewish faith. But you have to delve into the weeds and to the faith and the Jewish faith in order to give that exception. So I think the problem becomes that we have gotten into the weeds. And the question is this an area where we've gone too far, or where are we right on point with the fact that this person was, discriminated against, defamation was done?
Andre, am I in trouble now if I start trying to get the courts in the weeds of my religious experiences or in the weeds of what goes on in my church? Because the first thing the church will say is, we don't want the government in the weeds with us. We want them outside the building, outside our conversation. But it looks as though if you don't get in the weeds, how do you best protect your citizenry that still happens to be a member of a church?
Right. So this separation of church and court doesn't mean churches have complete immunity from litigation or liability. Churches and its employees and its agents can still be held liable in tort for negligence, breach of contract. Those still apply. But what this doctrine in this area has held is that courts have to stay out of the internal affairs of religious organizations because many, if not all, denominations operate from an ecclesiastical basis. So naturally, we don't want courts dabbling in that area.
Yeah, if I could just follow up with that. I mean, it seems to me that we need to put what's the facts of this case against a broader context here, because, we are increasingly seeing the doctrine of ministerial exception coming under attack. People are trying to narrow that exception in ways that would compromise, for instance, a school's ability to choose all its members of faculty, not just the Bible teacher, but all its members of faculty as co-religionists, as people who live out the faith, who will be an example to the children that they teach of that faith. And so, the Second Circuit's decision in this instance worries me because it feeds into this narrative that that churches should increasingly have their employment decisions scrutinized. And to me, that spells trouble going forward.
Well, Jennifer, this is where I think the concern is that on one hand, I'm supposed to allow my churches to do what they need to do. But the last thing I need is my church coming in and telling me, quote unquote, who should be a bishop and who should not be a bishop. That's basically saying who should be a pastor and who shouldn't be a pastor. Jennifer, I'll let you jump in on this, and Bake, you can come in after that.
Yeah, I mean, I think that, this is what everyone's kind of saying. We don't want government. We don't want courts getting involved in being able to dictate who can be, again, like a pastor, who can be a spiritual leader within a faith tradition. These are internal matters. And the moment that we start letting the courts get involved and decide the inner workings and whether or not those inner workings are correct, it's second guessing the tenets of one's particular religion. And that's just very problematic. And I think that it's problematic for the reasons that Bettina mentioned. We see this happening even now in the school setting as far as teachers and how far this ministerial exception, what the limits are and how it's trying to be reduced and limited in its scope.
Rashawn?
Yeah, I think you're absolutely right. But here's the thing that's interesting about what has happened, especially over the last 20 years, 30 years. Not only have individuals come to the court, but religious institutions have come to the courts. Just take, for instance, when a Baptist minister just doesn't make bishop and decides they're leaving the denomination to start their own, and you would have the church actually file suit against that person. And you'd have that person file countersuit against the church saying, I was elected bishop, but the election was faulty, and therefore I lost. And so what we found is a body of, cases coming about that have had the courts and the legislative body intertwined with the faith. And I think, that's where we see some of the problems. And in this case, as an example, once something like this case goes forward, then there are going to be other cases that come back and say, but this is the exception where the courts need to step in and need to give an opinion because I was wronged, and only the courts can do that.
Andre, this looks like this is where the rubber meets the road, because now you're really at that point where you're saying, okay, how do I make sure that I'm doing the best thing possible to protect churches? But the problem is that churches have not always been fair in how they've gone about their business. And most of the time, courts are getting involved because the churches overstepped. Am I missing something here? Or do we have a responsibility for the churches to also be doing what they're supposed to be doing under the right circumstances?
Well, if the church is behaving badly in the way it operates, that's incumbent upon us as church members, as participants in the governance process. I was part of the Committee on Governance for the North American Division of Seventh-day Adventists, where we looked at reforming the way we operate. And I'm a lifelong Seventh-day Adventist. I thought I knew how my church operated, and boy, I learned everything from finance to hiring to how we do church. And so for a court to come in and start to try to understand that isn't something they should be doing. If we have a church that's behaving badly in our estimation, then that's incumbent upon us.
So we're going to see this case moving forward, Bettina, moving forward into a next level. Should we be hoping that this court says, listen, hands off, this is not our call? Or should we be hoping that they come with something more specific we may be able to connect with going down the road? What would be the ideal scenario from your perspective?
Well, I wish I knew what was going to happen. I don't have a crystal ball, but in terms of what I would hope that the court would affirm church autonomy. As we've been talking about, it raises all sorts of really curly problems and really difficult questions. But, it is a foundation of our religious freedom in this country, and we need to protect it with everything that we can. As Andre said, it's incumbent upon all people of faith to hold their church leaders accountable. Yeah. It's not the role of the government to hold church leaders accountable for issues related to doctrine and faith.
Well, I think that's right on the head there, because the idea is that if the parishioners don't police their leadership, then that opens the door for government to want to come in and do the job for them. Andre, tell me something I don't know.
Did you know that only 2 Supreme Court justices have appeared on U.S. currency? Chief Justice John Marshall on the $500 bill and Chief Justice Salmon Chase on the $10,000 bill. Neither are in circulation today.
Good, because I was going to say I haven't had one of those in a long time. Bettina, tell me something I don't know.
Orlin, did you know that in 1393, a priest in the city of Prague became the first martyr in history to be killed because he refused to give up the secrets of the confessional? He was a confessor to the Queen of Bohemia. Her husband, the king, wanted to find out what his wife was up to, put pressure on the priest. The priest said no. He ended up in the river, drowned.
Wow, it's a little rough. Rashawn, tell me something I don't know.
Well, I can tell you that I learned a lot today on this show about things I don't know. Especially this segment.
Hey, Jennifer, tell me something I don't know.
Sure. Do you know that recent data has shown that Christianity has a major impact on how Gen Z understands injustice and society, and that most Gen Zers agree that their Christian faith is important to their understanding of what injustice is and how it should be addressed? Wow.
Unbelievable. Listen, ladies and gentlemen, thank you for being with us. Great information today. Looking forward to doing this again. Thanks again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.